Sean Manglotnya was convicted by a Superior Court jury on charges of advanced stalking in February of 2023. His accuser, a woman who had a stay-away order against Manglotnya at the time. Manglotnya is no stranger to the justice system, but he is fighting this conviction before the Supreme Court of Guam. His attorney, Peter Perez.
In this case, Mr. Manglonia's conviction must be vacated because the statute on which he was convicted for advanced stalking was unconstitutionally vague. And second, even if the statute passes constitutional muster under the void for vagueness doctrine, there was still insufficient evidence.
Too vague?
And those are the elements of maliciously, repeatedly, and in violation of a court order. We have Mr. Manglonia showing up at his former spouse's house 4 times. The first time was on or around the day that a stay-away order had been issued in another case. It was shown that he was knocking on the windows of his former spouse's house, calling out, "Babe." There were no interactions between he and the subject of the stay-away order. 60 days later, there was another contact. This time it was on December 19th at 6 p.m. He was found sitting down in front of his house while the alleged victim was parking her car, and there was an interaction at that time.
Justice Philip Carbolito, understanding the argument of a, quote, evil motive.
If there was a outstanding court order that applied to Mr. Manglonia to stay away from the victim, and the actions are that he came upon on the premises, the various interactions that you had started to itemize, then him just disregarding, again, going back in my mind, just disregarding the court order, then, and the court did the court define the word recklessly? I mean, he went in there with the intent to proceed to that he willfully, maliciously, and repeatedly proceeded to harass the victim in this case.
The justice getting into a back and forth with defense.
Despite the stay away order, doesn't that demonstrate a malicious behavior?
That would be for Your Honor to decide.
Right, yeah, but you can help me to try and decide that by
I can't because it's so vague. I don't know. Was there a required showing that the violence?
I don't think we have an issue with repeatedly and the court order being in existence. Is that correct?
Well,
your argument focuses on just a malicious definition.
As to sufficiency, but as to vagueness, it's all three. If he had come and told her, "I love you," he shouldn't have done that, arguably, because there was a court order saying no contact. Would an officer consider that malicious because he appeared in violation of a court order, arguably? Or if he said, I mean, the cases that the government relies upon, I mean, we're talking about protracted conduct of violence and threats. I'm going to kill you, you expletive, and actually harming somebody or threatening to harm them.
Well, wasn't there evidence of abuse already in this case, and that's why she got the stay away order? And so if he's coming in violation of that order, isn't that without legal justification, which, you know, at least could be defined as a malicious act, at least, you know, within the dictionary definition of what is a malicious act? It's one without a legal justification or excuse.
Maybe the problem really that I see is with no definition of malicious and having these different possibilities. How is an ordinary person to know whether they're committing prohibited acts, and how is law enforcement to know how to enforce it. And I think the danger is you're going to get multiple opinions.
The government's attorney Nathan Tennyson says the law states a person is guilty of advanced stalking if there's a violation when a temporary restraining order or injunction prohibits behavior against the same party.
A person is guilty of simple stalking if he or she willfully, maliciously, and repeatedly follows or harasses another person, or who makes a credible threat with intent to place that person or member of his or her immediate family in fear of death or bodily injury. So those are two separate prongs. We can find harassment, or we can find credible threat, or you could find both. But you only need to find one of those.
He says they met their burden of proof.
Mr. Manglonio went to the property 4 times while the protective order was in place. There's questions as to, well, what's the duration of repeatedly? Is it 1 year, 5 years? When do you break that chain of repeated? And in this case, I'd say that, and the jury would have considered this, that the protective order was in place during this entire period of time. And as a result, all of those visits during that protective order constituted repeated visits in violation of the protective order. A jury could find that those actions were malicious. There were jury instructions regarding just even reasonable doubt, and the jury using common law to draw inferences from evidence and to make determinations. I think at the heart of this statute in this matter really is the nature of conduct being restricted, which largely pertains to domestic violence situations. It can be very, I don't want to say the word broad, but it can constitute many different acts that in some cases could appear to be innocent but may not be.
And the argument and the evidence is that he was just there to visit his children. And that there was no ill motive, evil intent. And so since there was no definition of what maliciously meant, and there's a possibility of 2 different interpretations or 2 different definitions, how does the jury come about in forming a unanimous verdict? Which part of the statute is meant here in this particular case?
I think part of that can be addressed through the jury deliberation, but I think the other aspect of it is when the legislature passed the statute, I think in a way strict definitions of a word like malice, which, as I stated earlier, malice is, well, it has a couple definitions. They don't deviate from each other. They have the same core thrust as to a bad faith intent.
Justices took the matter under advisement.